Tell us what the matter is.
Your Lordship, is page 352.
Your own Khadi Village Industries Board you are fighting.
Yes, ma'am. Yeah, we are fighting for the state government.
I know, against this Khadi Village Industries Board.
Employees.
Employees.
Well,
Okay.
What has happened, my lord, that ORSP rules 1996 and the ORSP rules 2008, that has been extended them to subsequently. The Honorable Court has directed to extend them with effect from 1/1/2006.
With Lordship's kind permission. Usually in last occasion also in one matter, for last 1 year the matter was not listed, no interim order of stay has been passed. Your Lordship, what action you have taken to implement the judgment? Here is a case of 4 years.
Your Lordship has heard this matter several times. For that reason, both have appeared. For that reason, stay has not been granted. All have appeared in this
But
case
still,
several
you
times.
ought to have implemented by now.
But it has been, as they have been,
Contest is also pending.
and it has been heard several times. My Lord Senior has appeared from the as a caveator.
Not before this bench.
No.
No, occasion for several times.
It has come first time before my lords.
Yes.
I'm very
Tell us. I think it's better we finish it off.
Yes, my lord. You can. Your Lordship, turn to page 352. The impun order.
See, other boards are getting monetary benefits.
Yes. Well, I will draw my lord's notice. My Lordship has turned to page 364. What are the points for consideration before the Honorable Single Judge? Your Lordship.
Whether employees of the board are at par with state employees.
Whether the employees of the board are at par with the state government employees and are entitled to the benefits so far as the revision of scale of pay and other allowance available to the government employees. Whether the employees of the board are entitled to revision of scale of pay and DA in terms of ORSP rules 1998 and 2008 with effect from 1/1/96 and 1/1/2006 respectively, and release of arrear salary and allowance from such debt respectively. This is the point, in so far as first point is concerned, a Lordship, see para 23.
Yes.
The regulation prepared by the board in 1960 clearly showed that it is a schematic one. This regulation has been made to regulate the service condition, including salary, etc., of employees of the board. Clause number 8 and 40 of the regulation states as follows. Classification of employees. The employees of the board fall under two categories, namely regular establishment and schematic establishment. All posts under the board shall be classified by the board into class 1, class 2, class 3, and class 4 as specified in Schedule 1 thereto annexed, provided that at the time of creation of a new post not mentioned in Schedule 1, board will specify the class under which the post will be included. General conditions of service, unless otherwise provided in these regulations, the rules in the Odisha Service Code Volume 1 with all appendices except Appendix 1 to 4, 8, and 12, as amended from time to time by the government, shall apply to the employees of the board Mutandi. For this purpose, the word government and government servants and head of department whereof they occur except in chapter 1 of the code shall mean the board, the employees of the board, and the president respectively. For your service referred to in Odisha service shall mean post in class 1, 2, 3, and infra shall mean post in class 4. From the aforesaid provision, it is clear that the staff of the board is to be accepted as government servant. Because of that, they have adopted the Odisha Service Code. Honorable Single Judge said they are government servants.
No, what is your answer to that? Why should they not?
Because they are the employees of the board.
Whatever. So why should, if they, for all practical purposes, they are going to be treated as government servants? Practical purposes.
Yes, ma'am.
What is the problem
Yes,
in according to them the status?
Yes, ma'am. If they will be, once they will be treated as government servants, then they are entitled to pension.
Exactly.
In one case, if that your lordship has allowed their pension and directed to grant them pension, that was allowed by my lords, and that has been stayed before the Honorable Apex Court.
That is all right. That is anyway. That's a different issue. Whether ultimately the Supreme Court will permit it or not.
Yes,
that's different.
What I want to submit, my lord, if once they are declared as government servants.
No, that's how they've come to the court.
My lord.
They've come to the court saying, don't discriminate. For all practical purposes, you're treating us as government servant. Only for our pay and allowances, you're not giving us the same pay and allowances.
Because they are completely regulated by separate regulations.
Maybe.
Yes, ma'am.
In fact, that is what is being tested.
And they are the employees of a board.
Correct.
Once they are treated as government servant, then they are entitled to all the benefits that are to the government servants.
That is their argument, sir.
Yes, sir.
That is their argument. Why should that argument, why should it be negative is the question.
Once
No, there must be a rational basis. This is the Article 14 argument.
yes.
There must be a rational basis to say, I'll treat you as government servant for everything, son, but except salary, I will not give you. I will treat you as employees of a board, and I'll say board is not government, and therefore I will not give you salary. Which is what has brought them to the court.
What was their problem? They are not extended the benefit of ORSP rules 1996 with effect from 1/1/96.
Yes.
That we are extended them with effect from 1/1/2000. Though we have extended them from 1/1/96, but financial benefit we have extended from 1/1/2001.
So what is the logic? What is the logic?
Because of that was not only ORSP rules is applicable to the government servants.
Again, sir, it's again same.
Yes,
You're going in circles.
Unless that they are government servants.
You must explain a rational basis for denying them that benefit. That's all. Where is that rational basis? You can't say, no, they are board employees and therefore. That is not a rational basis. That's why they're coming to the court.
They are the board employee and they are paid by the board. And we only
they're not denying. Who's denying that?
And we release the granted only to the board.
Whatever, sir. Question is, if government servant is getting 300 rupees, why should they get 100 rupees for doing the same work?
They are regulated by their regulation.
That is the whole thing. So are those regulations fair? Can they pass the test of Article 14?
Yes, all employees are to be governed by their own set of regulations.
Correct. But if they, for all practical purposes, then don't treat them as government servants. For everything else, you want to treat them as government servants. When it comes to pay, you say, no, you're board employees, you're not government servant. They are questioning that.
The regulation is different. So
that's how they've come to the court, sir.
No, for that they have come in 2001. We have extended the benefit of ORS rules from with effect from 2001. That is they have never disputed their regulation. They have never challenged their regulation.
Why should they?
And they are the employees of their board. There is no dispute about
you yourself have clarified in the regulation that they will be treated as government servant.
No, that
regulation 40.
Regulation, they are not government servants. You'll also may see they are the employees of the board. That unless otherwise provided in the rules in the Odisha service shall except amended from time to either government shall apply to the employees of the board. For this purpose, the word government servant, my lord, and heads of department wherever they occur except in the shall mean the board.
Which means what? That's the same thing, sir.
You
want to bind them down by all the conditionalities attached to government servants.
My lord.
But when it comes to pay, you say, no, you're employees of the board, you're not government servant.
No, my lord, what has happened? My lord, board makes its regulation.
Yes.
And board makes its regulation, they adopt the government servant rules.
Right.
So according to them...
So for pay also, why don't they adopt? That's the only question. When you adopt it for all your other disciplinary action and everything, why don't you adopt pay?
No, my lord, what has happened? My lord, government is to release the granting aid.
Correct.
Board has recommended but the government is to release the granting aid.
Correct.
And that's so far as your lordship knows that so far as financial condition is concerned, accordingly government has released their granting aid.
And you know that the settled law, mere financial difficulty is not a ground to deny equality of treatment.
And we have extended them from a particular cut-off date.
That's it. There's no other argument.
Yes, that is the only ground. If your lordship will treat them as government employee.
All right. You say two questions were taken up for consideration by the learned single judge in the impugned judgment dated 9th February 2018 in writ petition civil 4802 of 2011 filed by the respondent number 1. Then copy these two questions at page 364 paragraph. In answering question number 1 above, The learned single judge took note of the applicable regulations and came to the following conclusions. Reproduce whole of paras 23 and 24. In view of the above discussion, the learned single judge answered question number 1 in the affirmative paragraph. Learned counsel for the state / appellant contends that members of the respondent number 1 union continue to remain employees of the board by virtue of the separate set of regulations, and that the government merely releases a grant to the board, which then makes the payment. Full stop. According to him, merely because the explanation to Regulation 40 requires employees of the board to be treated as government servants for the purposes of disciplinary action, would not ipso facto make them government servants eligible to the same scales of pay as government servants. Paragraph. The very question before the learned single judge was whether there is any rational basis for discriminating against employees of the board vis-a-vis government servants, despite subjecting them to the same regimen as full stop. Indeed, the learned single judge indeed the state was unable to place before the learned single judge any rational basis for this differentiation when it came to the matter of pay. And even before this court, no rational basis has been presented. Paragraph. In fact, question number 1 is also tied up with question number 2, where employees of other statutory bodies, that is the Mahila Vikas Sambaya Nigam, the State Social Welfare Board, the State Hajj Committee, the State Waqf Board, the Sri Jagannath Temple Administration, the Utkal University, the University of Agriculture and Technology, and the Odisha Water Supply and Sewerage Board have been treated on par with the state government itself when it comes to terms and conditions of service of their employees. Full stop. In fact, counsel for the appellant state concedes that even the employees of the board have been given the benefit of the ORSP rules 1998 and 2008, but only from 1st January 2006 and not earlier. Full stop. Again,
2010. They have given from 2010.
From 2010 and not earlier. Here again, the state has not been able to show what is the basis for discriminating against employees of the Khadi Village and Industries Board vis-a-vis employees of all other statutory bodies mentioned above. And what is the rational basis for restricting the benefit of the applicability of the ORSP rules only from 2010. Paragraph. Consequently, even on point number 2, the conclusion reached by the learned single judge in favor of respondent number 1 cannot be found fault with. Paragraph. The court is therefore not satisfied that the impugned judgment of the learned single judge suffers from any legal infirmity that calls for interference. The appeal is dismissed.